We also need to think about the best process for moving from the debates that we have about rights and wrongs to the formulation of the legal rules that we hope will follow, or at least be connected with those discussions. And in the UK at the moment, we are having a debate about the extent to which that should be done through the courts, particularly if it's seen to be a matter of fundamental human rights, and the extent to which this is a matter for democratic deliberation and decision making, so that the guardian of the law relating to end-of-life care on this model should be Parliament. So I just want to raise with you some of the sorts of things that are said about that question. Traditionally, the courts have expressed some anxiety about their role in relation to contested bioethical issues, and they've said things like Parliament is the conscience of the nation, and as the conscience of the nation is the appropriate constitutional forum for deciding these questions on which society is divided. They worry about judges being influenced by their own particular moral perspectives, and judges come typically from a reasonably homogeneous background. They're not representative of the broad range of views or the broad range of experiences. They also worry that the litigation process brings unrepresentative cases before the courts. It brings a set of cases that are largely there by accident, possibly because the litigants feel especially strongly, or maybe they just have the financial resources to instruct lawyers, or maybe they're particularly difficult so that the clinicians can't really work out the best way forward and can't persuade the families of the appropriateness of their views, because these are just very hard cases. And it doesn't necessarily make sense for the courts to generalise ordinary rules from extreme and untypical cases. So there's something about the worry about using litigation in a judge-made law process, as we have in the common law system, to deal with that. And linked with that, typically you have very strong voices from the people immediately involved, but they may not have a perspective of the broader issues. Although this has been remedied in some of the recent litigation by allowing people to make interventions to explain the wider ramifications and the fundamental principles that are at stake. So a number of pro-choice and also pro-value of life groups have had the opportunity to become involved in the cases that have been litigated through the courts in recent years. But there's still a big worry that the sympathy for the individual claimant or the particular tragic circumstances that are there might evoke a degree of sympathy that leads to a conclusion that, when generalised, has unforeseen and unintended consequences. So one judge in the High Court in the case of Nicholson captured the reasons why the court should be wary about being drawn into making rules on these contested issues in terms of their competence to take those decisions, because what they required you to do was take a very specific case and generalise out of it. And that seemed to be a dangerous and unwise step to take, because the courts didn't have the opportunity to look at the full range of circumstances and implications. Secondly, as Justice Toulson, as he then was in Nicholson, raised questions about the proper role of courts and Parliament. So he raised constitutional questions about the fact that in these matters, if Parliament was the conscience of the nation, it was for Parliament, not the courts, to determine those questions, and therefore the judges should be very reluctant to be sucked in. In the Supreme Court in Nicholson, the judges tried to capture that by saying that while they had the constitutional right to check whether or not human rights were being properly respected, institutionally it would be very rare that they would seek to exercise that, and they should usually expect Parliament to do it. So the first worry was about the competence of the court to get effective general rules out of specific circumstances. The second one was the appropriate of them rather than Parliament doing it in our constitutional system. And the third reason why it was thought dangerous to do these things through litigation was that the choices that the courts have are really very limited. They can either say one side wins or the other side wins. Whereas most systems for providing an effectively regulated assisted dying process or euthanasia process will want to have a set of safeguards and a set of criteria that the courts can't just say are in place and must almost be followed, because all they can actually say is that the case in front of them should be decided in favour of either the claimant or the defendant. So there are good reasons to be anxious about the courts as a process of taking these types of decisions. An orthodox view of the separation of powers, the difference between the law-making process, which usually sits in the legislature, in Parliament, and the job of applying the law, which is thought to sit in the courts, would suggest that the courts should be very wary about getting involved in these cases, and that the series of test cases we've seen brought before the UK courts would seem to be in breach of that approach to properly making law. On the other hand, we also have to worry about the tyranny of majority problem, the idea that one group in society can impose its view on others. And we also have to recognise that the quality of debate in the legislature is often patchy. The volume of legislation that goes through is often too great for there to be close scrutiny. And not everybody would see that the debates that actually happen in Parliament are ones that stand up to philosophical scrutiny. So I invite my students each year to have a look at some of those parliamentary debates, and they will typically tell me that they see the debates as highly anecdotal. They find it very hard to trace through the arguments of principle into the decisions at the end of the process, because it's a melee of discussions, lots of voices, a bit of argument, and then they just have a vote on the end. They don't explain why the vote has gone the way in which it is. So you don't necessarily see the parliamentary process as being that close to philosophical ethical debate either. We don't elect our MPs to be moral experts. Some of our members of the House of Lords, the revising chamber, are there because they have particular experience and expertise in healthcare or philosophy, but most of them don't. And many of them talk in their debates in terms of the experience of their friends or family, and it's not obvious why that experience should be privileged over others. So we might, instead of the courts or democratic debate, look to some form of expert commission. Many countries have national ethics committees. In the UK, the nearest equivalent to a national ethics committee, the Nuffield Council on Bioethics, focuses on new developments in technology, not age-old arguments like those over abortion or euthanasia. And we've seen in the UK a private commission funded by people who believe there should be a change in the law, which took evidence from many people, evaluated that evidence, considered options from other countries, and came up with some proposals that would be a model for reforming the law. And that might be a more efficient way of connecting moral debate and legal proposals. But it still has to get through the democratic process, and those recommendations from the Falconer Commission have failed to win support in Parliament and have not become law. But it's worth addressing our minds to the pros and cons of these different sorts of approaches. Should we see this as a quintessentially legal matter, fundamental human rights, in which case the courts are the appropriate guardians? Should we see this as a question of society making up its mind through democratic processes and just the same as other choices that society needs to make about the values that it espouses? Or is there something particular about bioethics that lends itself to a deliberative process that brings together opinions and evidence and arguments, and doesn't just count at the end to see who's got the most support in the way that a vote in Parliament does, but seeks to reason its way to a set of proposals which would give you some confidence that an attempt is made to make sure that the legal proposals that emerge have some foundation in reason and argument?